advanced legal English course for teachers, students, test takers of Toles exams, and for paralegals, lawyers, and any other legal specialist. So today we will delve into the topic of company law. So we will learn and study and advanced English phrases, words, phrasal verbs, collocations, and many other vocabulary with the definition. Actually, we do have the reading extract, actually the reading article with the task. Let's get started with the reading. So here it is, the reading part and the article about company meetings. So here subheading board meetings. So we do need to fill the gaps with the appropriate word and the best solution we should find from the options. So let's get started. The articles of a company will pass, deliver, delegate, or convert. So our appropriate word is delegate. So the articles of a company will delegate the management of the company to its board of directors. So it means will be delegate the responsibilities and duties. That's the definition of the delegate verb. The next, the board will act collectively, meeting regularly to consider and decide ideas, issues, problems, and influences. Our close option is issues. Decide issues. That's the expression. So, decide issues affecting the company. So, it should actually make a sense on your statement. Next, how those board meetings are run is a matter largely, not mostly, not preferably, not importantly, largely for the articles and for the board itself to decide. So matter largely or think largely. That's the same, actually, almost the same. Next, unlike shareholders' meetings, which are more tightly regulated, board meetings are generally what? Absent, unrestricted, free, and closed. Actually, we do have here the preposition of. So free of legislative interference. Next, so there is nothing in statute about a notice to be given for board meetings. Any director or the secretary can call a board meeting and, unless the articles or a previous board meeting have stipulated a length of notice to be given, the only need, restriction, requirement, and demand. Our correct word is requirement. The only requirement is that it be reasonable. Next, what is reasonable will depend on the type of company and its past practice. For a private company where all directors are already on site, reasonable notice may be a few hours or even minutes. For a large international company with directors scattered over the globe and non executives with other responsibilities, board meetings will be fixed a year or more in advance. Not future, not anticipation or ahead. Actually, that's the expression in advance, beforehand. Again, unless the articles or a board resolution say anything to the contrary, the notice can be written or oral and need not detail an agenda for the meeting. So that's the end of this article regarding board meetings. Let's go next for the second part of the article. But before that, we do have pro tip here. So we need to make sure that your choice of word collocates. So that's collocations or phrasal verbs or expressions, as I said previously, with the word coming before or after the gap, as I told you. Sometimes you need to look beyond the words immediately, following the gap to find a clue or a hint. Always read through the whole sentence to not to miss any other tips. Next, the rest of the second part of the article is notice. All shareholders are entitled to receive written notice of a meeting unless the articles say otherwise, not alternatively, not different, not opposite. Otherwise, a smaller company's articles may often state that notice is only to be given to those shareholders who have provided a UK address to the company. Next, you can see here the preposition in. So that collocates with addition, not fact, not extra, not advance, because here we need to actually catch the scenes. Notice of a general meeting must also be given to each director. So that's additional information, not the fact. In addition, blah blah blah, the next, each director, whether, it's not if, because we do have in the middle of the sentence all. So that's why I've highlighted and marked this. Whether or, either or, neither nor. So here it is, whether is appropriate word, which is allocate with the or, whether a shareholder or not, and to the auditors a point that can often be missed. The articles will state how notice can be given to shareholders, and it's important that their provisions are followed. Failure to do so can, here we do have some options: negate, illegalize, invalidate, and deny. Actually, the notice can be invalidate or validate the meeting and the resolutions passed at it. The next, legislation introduced in 2000 allows notices to be sent electronically by email or fax if a shareholder is in agreement. So they agreed. Here it is, 11s have acceptance, understanding, and accord. But we need the word agreement. Next, since January 2007, a company has also been able to use a website. Documents and information to be sent to shareholders can be posted on a website if a shareholder resolution allowing this has been passed or the articles permit it. Shareholders can opt out, not choose out, not make out, not go out, opt out and still require hard copies through the post. In any event, each time a document is put on the website, shareholders must be told, usually by hard copy letter. So that's the end of our reading actually section of the Toles and the legal English and any other Cambridge exams lessons belong to students, teachers, and any other legal specialists, paralegals. If you would like to get such kind of more and profitable video lessons for free, kindly ask you to subscribe my YouTube channel, like my video, and also watch this presentation in PDF format will be held on my Telegram channel for easy downloading materials. Thanks for watching.